False. Robson never performed in commercials or took part in photo shoots in connection with his employment with the corporations. Commercials and photo shoots were for third parties, Pepsi and LA Gear. In fact, the LA Gear commercial and photo shoot happened before Robson was ever employed by the corporations. All in the record at Volume 6 of the Redacted Appendix, 3718 and 3734, Volume 7 of the Redacted Appendix at 4309 to 4310. The only employment by Robson was in 3 music videos in late 1991 and 1992. And then he was signed to a non-party independent production company that's then signed a record deal with a joint venture record label with MJJ Ventures. And he's never contended ever that there was molestation in connection with recording of his own album. So there just was no other employment contrary to what the tentative asserts. And it's notable that the evidence is undisputed that Robson was never even at Neverland from September 1991 when he first comes to the United States and then is first employed for these music videos until July 1993, until all the music videos are over. Okay, and how do we know that he was never at Neverland during that period? The testimony of Joy Robson, Volume 9 of the appendix, the Redacted Appendix 6904, just before the allegations against Jackson were made public. And we know this from Mrs. Robson's deposition, as I said. This 1993 date is key because of the tentative's very brief and we think erroneous analysis of causation, which says that, well, we don't know what could have happened before 1993, but we know he was never even there at 1993 when he was an employee, before 1993 when he was an employee.
Mr. Steinsapir, I just want to let you know you've got less than a minute remaining.
And thank you, Justice Grimes, and I'll just wrap up with this. Okay. So there's no evidence of abuse during the limited period that Robson was employed. The employment relationship is the key to the special relationship. The evidence is undisputed that there was no molestation in connection with the employment. Robson was never even at Neverland. And again, I want to close with this. Consolidation in an appeals court, not a trial court, in an appeals court is uniquely within your discretion. We certainly agreed that consolidation for purposes of oral argument was correct, and consolidation for purposes of an opinion, that's fine. I'm not in the business of telling anyone how to write opinions. But the tentative needs to grapple with the record in the Robson case as opposed to the allegations in the Safechuck case. And with that, unless your honors have questions, I would submit. Justice Wiley.
Well, actually, I do have a question.
Sure.
Counsel, can you hear me?
I sure can. Thank you.
Would you agree that the California Supreme Court thinks the overall mission of tort law is to reduce the social costs of accidents?
Absolutely.
And it seems to me that these corporations were in an excellent position efficiently to take measures to avoid these alleged injuries. Do you agree?
No, I couldn't disagree more. And I think if you look at the record and look at what these corporations did, particularly given that these are Michael Jackson's corporations, there to service Michael Jackson, no. And when you look at the proffered duties that the court's tentative has put forward, none of those duties would prevented anything. We know that people went to the police, and Mrs. Robson was perfectly okay with it.
So the corporations were, I guess you'd agree, in a position to establish policies, for example, that there would have to be a chaperone present whenever Michael Jackson was alone with these children.
No, they were not in any such position to do that.
They could have done. They could have done that, though, right?
No, they could not have done that, Justice Wiley.
Why is that?
Because they had one shareholder named Michael Jackson, and he couldn't do that. Secondly, this was all happened at Michael Jackson's home, and I don't know about you, Justice Wiley, but companies I had to work for are not allowed to tell me who I'm allowed to be with in my own home.
So you're saying that the corporation couldn't have established an accident prevention rule because its shareholder was the very problem?
Yes and no, but I think, again, you're overlooking the fact, Justice Wiley, that this was all in Michael Jackson's homes, as Judge Young and Judge Beckloff said. So you're saying a corporation, my law firm, could tell me whom I'm allowed to be with at my own home? I mean, is that a serious?
Certainly, any entity can lay down employee protection measures. And one measure might be you're not allowed to take a child home.
And then what? So let's talk about what would happen. So then they would fire Michael Jackson, okay? And Michael Jackson would still be Michael Jackson, and he would still be able to do what he wants. I mean, the fact is, and I sense this from the tentative, the probate claims filing requirement seems to not be in vogue here. But that's what shuts down this case. Because if Michael Jackson were alive, or if they had filed claims, you would just sue Michael Jackson. We wouldn't be talking about negligence and all this stuff. You'd sue him. The question would be, did he do it? Didn't he do it? It'd be a swearing contest between Wade Robson and Wade Robson. And, did he do it or didn't he do it? Okay, but the fact is they blew those deadlines. And if you get a judgment against Michael Jackson, which of course we never think would happen, but if you did, or against his estate, these corporations and all other assets would be subject to that judgment. So what we're doing is we're manipulating tort law to get around the claims filings requirement. And just one final point, Justice Wiley, on accident protection. You're a professor at UCLA, and I'm sure you got the same hypothetical I did. Look, the common law is that an Olympic trained swimmer can walk past a swimming pool and see a child drowning in it. And if there's no special relationship, he's not a lifeguard, this and that, he's allowed to walk past it. Okay, that's a very harsh rule, but it is the rule. And so, yes, the purpose is accident protection, but we don't just create duties to act when there aren't any. And I think the two judges who looked at this case very carefully, they came to the right decisions, and I would ask the court to rethink its tentative and to affirm. Thank you.
Thank you.
Thank you again, Mr. Steinsapir. We very much appreciate the points you've made.
Thank you, Your Honor.
And Ms. Boyer, would you like to proceed now?
Yes, thank you, Your Honors. Just a couple quick points. I think largely the arguments raised by my friend on the other side are the same arguments that we saw in the briefing, addressed with in the reply briefs with responses and citations to the evidence. I think the fact that the last point that was just made about the probate claim and that this is the way to get to the defendants ignores the defendant's actions. Throughout the briefing and in argument, it appears that defendants don't believe they did anything wrong. The example that they are a bystander walking by a child drowning in a pool, kind of the example he was just giving, ignores the fact that they facilitated that child being at the pool. They picked up the child, they drove the child to the pool, they took his parents and put them in the other room. So there was a role that was played that I think is ignored. I also want to focus just briefly on some of the arguments. The first argument concerning consolidation, I think this court went through and articulated the differences in the two cases, the factual differences, and specifically noted when there were certain arguments applicable to Wade Robson's claim on summary judgment. I think that the defendant's position that there were no triable issues is just through the distorted lens they are looking at the evidence through. With regards to the special relationship between plaintiffs and defendants, I think again, and the point that these were his private houses where these happened, where the abuse occurred. I think again, defendants ignore the fact that these houses were staffed by defendants' employees. Defendants employed Jackson, they employed plaintiffs. There is plenty of evidence of that in the record. They employed the staff who then enacted policies and procedures to isolate Jackson and these children, knowing that Jackson had sexually abused minors before and was sexually abusing these plaintiffs. So, the idea that there is no responsibility to do anything ignores the context. And I think what was very poignant in the court's opinion is looking at the circumstances of this case and the special relationship that arose given these circumstances. These are children. Plaintiff Wade Robson was 7 years old when he was first abused by Jackson. James Safechuck was 10 years old. Their dependence and vulnerability are implicit in their age. And I think the idea that the parents somehow, their role in this, disposes of the duty, again ignores the context of how this sexual abuse occurred and the role defendants played in absolutely taking care of plaintiffs while they were within their care and custody, while they were in the car being driven to Jackson's literal doorstep, and then policies to stay away from Jackson and the children. So without repeating everything in our briefs, I think that the arguments advanced kind of ignore the actual conduct taken by defendant organizations. Let's see. And with respect to kind of the going through the duties alleged, the duty that the defendants could have done something. Defendants spend time on kind of these hyperbolic concerns about, oh, a low-level employee would then have to, confront a supervisor, and what would happen? Well, in cases of an affirmative duty to protect children from sexual abuse, we do require that the employees of the entity take those steps, because at the heart of what we're talking about is the sexual abuse of children, which is something we need to protect against. So, I think in closing, unless the court has questions, I just want to kind of remind the court and the parties that what we're talking about here as 7- and 10-year-old children who are entirely ill-equipped to protect themselves from sexual abuse by their trusted mentor, Michael Jackson. And they were not even aware that the expressions of love offered by Jackson were indeed torturous forms of sexual abuse that haunted these plaintiffs for the rest of their lives and into adulthood. And plaintiffs were left alone in this lion's den by defendants' employees. I think the court's point in its tentative that these circumstances undoubtedly give rise to a special relationship and affirmative duty to protect and to warn is correct, and we agree with the court's tentative in all those respects. If the court has any questions, otherwise we submit.
Thank you, Ms. Boyer. I don't believe we have any questions. And Mr. Kunkel, Ms. Boyer didn't say anything about our tentative ruling in your favor on the discovery order. So do you submit on the tentative?
We do, Your Honor. Thank you very much.
All right. Thank you, counsel. This is a very difficult case, and we appreciate the gravity with which you've treated all your arguments. This matter is now submitted. And Presiding Justice Stratton will take over the calendar. I think, but I'll go ahead and call the next one because she's not on it. People versus Guerrero.
Justice Grimes, this is Myra. I believe we were going to take a 5-minute break after the first matter.
I forgot all about that. Yes, we will take a 5-minute break until 9:49 precisely. Thank you.